And we're back with Christie Register talking about preparing for bankruptcy.
Hey, Michael.
Hi, Christie. Filing bankruptcy is a huge step in somebody's life.
It is, but it's not like climbing Mount Everest. There are some steps you have to take. Your bankruptcy lawyer can help you with each step, and then you're prepared to file. So a lot of people think that it's going to take over your life. No, there are a few things you have to do. We do it, and then you're ready to go.
But like climbing Mount Everest, there's a lot of steps you need to go through along the way, little base camps.
Right, and you know, I tell everybody our goal is to have a perfect petition, have everything exactly right. Now, sometimes that doesn't happen, and we can amend, but it certainly helps. You know, we've got a questionnaire, and at the top of our questionnaire, I have please fill it out completely. If you're not sure about something, ask us, because you want to get it right. It's a federal petition. You're signing it under the penalty of perjury, so it's good to have all the documents you need, which most people have anyhow. Pay stubs, tax returns.
Okay, we're going to go through a list, but you mentioned something very important just then, under penalty of perjury. Is this one of the few cases where perjury actually gets used? Do people get in trouble for lying at bankruptcy?
If the trustee believes that the debtor is intentionally trying to conceal something, then yes, they will raise the issue with the judge, and then the FBI can get involved. So I'm always careful to remind people, this is a federal law. Now you have to tell the truth. So it is not for people who are trying to hide assets and get out of paying the creditors. It's for the honest but unfortunate person.
Are we talking about grandpa's watch or like 100,000 shares of stock?
We're talking about, you know, you're supposed to list everything you own and list everybody you owe. So, you know, you have to list every piece of silverware. No, but if you've got a grandpa's watch that's worth $20,000, absolutely you have to list it.
Okay. You mentioned your list. We've got it here in order. Our first one is all bills and credit report.
You don't necessarily have to have your most recent credit card statement, but a credit card statement, you need to list the creditor's name, address, and the account number. Now, we use a system with our bankruptcy software program that will pull a credit report, incorporate it into your petition, but just to be safe, I like to have the bills to compare and make sure it got listed. Every now and then, you may have had an account with a bank or a credit card company. It's nowhere to be found on your credit report.
Okay, and then our next one is tax returns for 2 years.
Right. We have to provide that to the trustee. That's part of the law, that they have to review those tax returns. Plus, we need to put it when we're reporting your income for the last several years. So that is something that we absolutely have to have a copy of. So if you were in a position where you were required to file tax returns, then, you know, the last few years, then you have to file them, or you can't be in bankruptcy. You can't be in bankruptcy and not file your tax returns. Now, that is not for people who don't meet that threshold requirement of filing. So if you're on Social Security, or if you didn't make enough income to file, then that doesn't count. If you did make enough income and you were required to file and you haven't filed, you have to get that done before you can take advantage of the privilege of bankruptcy.
And what if you're operating a business like a sole proprietor, and the company may have went through X dollars, but you didn't keep any of them?
They'll look at businesses, but they look at your income. So, you know, a lot of people may operate, but they operate at a loss, so that your gross receipts don't count as your income.
Does that make you also have to take your company bankrupt as well?
No. No.
Okay.
And often what I find, small business owners like myself, if you get a loan for your business, your name is on it individually, because obviously banks have learned that businesses may come and go, but they want somebody, a living, breathing person that they can have on the hook. So, you know, if you find yourself in a situation where your business is going to have to close, often the business doesn't need to file bankruptcy, doesn't need to file Chapter 11 or Chapter 7, but the business owner may need to file because they're on the hook for all those debts that didn't get satisfied.
Okay. And then we have payroll advices and income statements.
Yeah, if you are employed and you get a paycheck, then we have to file with the court your pay stubs for the last 2 months. It could be a pay history. Larger companies, their payroll office can give you a pay history that just has a printout of the checks that you've gotten for the last 2 months, the gross, the net, all that, taxes taken out, and that's all we need.
Okay, and what if you're one of the people on one of our previous shows that have been laid off and maybe it's been 6 months since you worked? Then you don't have anything in the past 2 months.
Then we submit the transmittal of pay advices that says that none are attached because the debtor wasn't employed.
Would unemployment count?
No. We have to include that as your income on your budget if you're still receiving it. But no, they're looking for pay advices from employment.
Yeah. Does unemployment benefits count toward bankruptcy, helping decide if you're eligible or not?
They count as income.
Okay.
Yes. To do Chapter 13, which is reorganization lasts 3 to 5 years, it has to be feasible, which means you have to have enough money to be able to meet your basic living expenses and make your bankruptcy payment.
Okay. And then our next one's bank statements.
Right. The Savannah Division trustee wants to see bank statements for the last 3 months. Again, that's something that people can often pull up online in our office. So it sounds like it's a lot, but it's really not. It's just a few steps that you have to take, and then we're ready to go.
Okay, our next one is a credit counseling certificate.
That is an absolute. There are few exceptions that you can ask the court to excuse you from having to take a course, but the general rule, everybody has to take credit counseling course. That was part of those big changes back in '05. That was so monumental that in 2010 we're still calling it the new law from back in '05. You have to take credit counseling. You can do that in person. There are offices in Savannah. You can do that on the phone. You can do that on the internet. We really do everything we can to accommodate every kind of person. Telephone, in person, internet.
Okay.
Make it as easy as we can.
And then the last one on here is something called a RLF questionnaire. Now that seems familiar somehow.
Yeah. I've spent so much time on this questionnaire of ours.
And that's Register Law Firm.
It is, right. That is our way of communicating with our client. It is lengthy, and I know it's lengthy, but so is a petition. We need all the information. We have it on our website, so you can download it at home and take a couple of evenings, to fill it out. Instead of sitting down, it doesn't take a long time, but it may take you an hour to fill it out. We need all that information, though.
And then for Chapter 7, they need to be able to make a payment toward it?
Chapter 7, the fees have to be paid up front, the filing fees, the attorney's fees. Chapter 13, those fees can go into the plan. Chapter 7, there is no plan. You're not making payments to the trustee in Chapter 7, so you have to pay those up front, but often it's less expensive than filing a Chapter 13.
Okay. If you have any questions you'd like to ask Christie about bankruptcy, you can reach her through our toll-free number at 888-2037-LAW or through our website at talkinglawtv.com. We'll be back with more right after this. Stay tuned.